I'm Cristina Caffarra. Very warm welcome on this European Competition Day, a day we had hoped to spend together in Lisbon, finally meeting old friends. It wasn't to be, unfortunately, but hopefully that moment of reunion isn't that far away. The panel is about digital markets, the road ahead. And we certainly have come to a great big turn in the road, what I call a great pivot towards regulation, not just in Brussels at the European Commission, but also in the UK, in Germany, and now, interestingly and amazingly, also in the US. We've all seen the introduction at the end of last week of a set of pretty radical draft bills with bipartisan support that make anything we've seen in Europe really look quite rational and conservative. So we have great experimentation going on with regulation at this point, with different models, the DMA, the DMU, the revised competition law in Germany, and indeed this draft bill in the US with titles which are exceedingly evocative, like the Ending Platform Monopolies Act. So we're here to talk about that. It is, of course, a complement to antitrust, or perhaps in part a substitute at a time when antitrust is not credited for having achieved that much in this space, notwithstanding great effort and well-meaning work. But of course, it is not over. There's more and more antitrust cases popping up every day, being open. So will it work? How will it work? How will it be deployed alongside antitrust? Will it solve the problems? What's missing? How will it be implemented? With what competences? Will the digital giants play along or play dead? So to discuss all of this and more, we have an exceptional panel. I'm delighted to be moderating. We have, of course, Olivier Guersent, Director General of DG Competition, Professor Massimo Motta, who was previously Chief Economist in DG Competition, but is now an academic and continues to be very involved in the policy debate with drafting and writings. We have Agustín Reyna, Director of Legal and Economic Affairs at BEUC, the European Consumer Association. And last but not least, we have Philip Marsden, who really is someone with multiple personas, who was on the CMA board, in the Furman Report, Bank of England, FCA, long distance runner, conference performer. I don't know if he's going to burst into song, but I hope not in the course of this panel. With that introduction, let me start with the first topic. I think I want to start with mergers, really. And the reason is that I think there's a reasonable consensus right now that the reason we are facing what we're facing, which is the pretty untamed massive market power, is not only because of their organic growth, but also because we have seen a succession of acquisitions and mergers, and there is a big debate about whether we have, in some sense, let that happen without enforcing sufficiently. Now, I don't want in this panel to look at the past, but look forward. We now know much more than we used to. We know, indeed, that power has been accumulated through acquisition. We know far more about the importance of potential competition in this space. And let me just throw in a couple of points. First, now the Commission has advocated the right to look into many more of these deals with the referral under Article 22. And the question really is, what is the standard under which they will be reviewed? Don't we know much more now about how these mergers can lead to potentially harmful effects? Don't we know much more about how the political economy has moved, and we need to think about all this? Finally, we know, for example, we observe the UK on its side being very militant about this. They block a lot of things. They are very animated by potential competition. They do killer acquisition, reverse killer acquisition a lot, and have adopted a standard of proof that is more stringent for these deals. In a sense, they have moved from a balance of probabilities to a realistic prospect, which is a significant move. And finally, we have seen the French and German and Dutch politicians express a view that the DMA should be more robust on mergers. So let me start with Massimo in all of this. What is your view about where we are and what we should be doing in mergers, Massimo, in this space?
Thanks, Cristina, and good morning to everybody. Thanks for inviting me to this, and it's a pity not to be in Lisbon with you. So I completely agree that there has been insufficient enforcement in merger control, and I'm also aware that there might be legal and that the DMA in particular maybe could not change completely the scenario for merger. But I do think that it's important to do something, and we should be going towards something, as you said, there should be more robust merger control. There are many different in which we should approach the issue. The first one is, of course, notification. Then we'll have burden of proof, standard of proof. So let me just briefly go through these issues. So first of all, notification. Well, on the referrals, I think Olivier is probably better in a better position than me to say to what extent this will help. My impression, for the little I understand, is that of course when you have the possibility to have more referrals from member states which are using different criteria, such as share of supply or even transactions, might help. Although this might not be enough to catch all of the takeovers that we might want to catch, because we know that there have been literally hundreds of takeovers of startups by the big platforms, and in many cases, in the vast majority of cases, these were young potential competitors, and it's possible that neither the current share of supply nor the value of transaction criteria, let alone the usual turnover threshold, might actually catch those mergers. So I think that this is the first thing to do, in my opinion. The best thing to move would be to oblige certain firms to notify. So, for instance, say the gatekeepers in the DMA should have the option to notify their mergers. So that would be the first thing. I believe also that part of the problem is, of course, not only due to the notification thresholds, but also to burden and standard of proof. I have been advocating for a very long time for a reversal of the burden of proof in many situations when you're talking about horizontal mergers with firms which have sufficiently high market share. So at first, I would ask for the reversal of the burden of proof when we are going to talk about these digital gatekeepers. Note that reversing the burden of proof doesn't mean that a moratorium on all of these mergers, because we also know that some of these mergers might well be pro-competitive, and in particular, we are talking about the possibility that small startups are resource constrained, and the possibility to rely on the resources of a larger firm might be a very good idea. Standard of proofs, I completely agree with the direction in which things are going into the UK. I think that the realistic prospect test should be welcome. I think more in general, I think we should use something like a precautionary principle. That is, that if there is some probability that a startup will be able to develop into a competitor of a gatekeeper, then the merger should not be ahead, which is, again, part of the reversal of the burden of proof story, cast in slightly different terms. And in general, one other way to frame this issue about standard of proofs is to think in expected values. That is, there are some mergers which might kill a startup, which has a small probability perhaps to be able to contest the gatekeeper's position. But if you were able to, then there would be huge gains. So using a sort of expected value type of framework would be very helpful. Finally, one last thing, which to some extent has not been part of this debate, or perhaps it has entered only in the case of the recent Google Fitbit merger, is that it's not only a problem for mergers, is that I see with much worries when there are the big digital platforms which are entering markets such as healthcare, finance, insurance, etc., because this is going to lead to, sooner or later, is going to lead to discriminatory terms for consumers, to the possibility that some users are not going to have access to certain products or services because the platform is able to know a lot about what the consumers do, and might decide that it's much more profitable not to supply certain products. So again, they might enter these areas not only through mergers but also through organic growth. But obviously when this comes through a merger, it's much more immediate, and I think it should be tackled as well. So in a way, I think sooner or later there should be a debate also about the possibility of introducing line of business restrictions in some areas, which is a debate that we have not seen, but I think it should soon come. Thank you very much.
Thank you, Massimo. A strong message there, particularly useful to mention in the end, of course, of the line of business restrictions beyond mergers. Let me turn to Olivier. Olivier, I think, again, the issue here is not looking at the past, whether particular cases should have not or should have gone through. It's looking at the future. And it is really the standard of assessment, I think. We see, of course, even the US new draft bill at this point brings in quite extraordinarily a reversal of the burden of proof. There is essentially a blanket prohibition with some exclusion. In general, we feel that this space is one in which the burden of proof really needs to be thought through quite carefully. What is your view on that? And more general.
Well, thank you, Cristina. It's a bit strange to be in a panel of myself here physically in Lisbon. It's also a bit strange to be the only one wearing a tie. Normally I'm the only one not wearing a tie, so there's clearly something I did wrong this morning. Well, anyway, no, thank you. I think, though, it's important to look a bit at the past, because for the last 20 years, the European Commission and the friends within the ECN, we felt a bit alone enforcing tough against giant tech companies. And so now it's fashionable, everybody's joining the club. But I don't think we took our share in the under-enforcement, if there was an under-enforcement. I think we have been enforcing our standard. There's a different question is whether we should change the standard, and I'll come to that in a second, in a pretty consistent way. So if you take even very recently Google Fitbit, I think we extracted from this case the most that can be extracted with the current review standard. And if you consider that competition law instruments are here to deal with competition issues and not necessarily with all other issues under the sun in terms of privacy, data, etc., which are very interesting, but should be dealt with by other legal instruments, in my view. So that's not to say that a data issue cannot be a competition issue. Of course it can, but it's not necessarily. And it creates issues in its own right. So the first question, logically flowing from your general theme, is should we enforce more toughly the current standard under the EU merger regulation? My view is that we cannot. My view is that we have enforced and we are enforcing the current standard as tough as we possibly can, while keeping up with the way we enforce it in all other sectors. And I think if we would want to enforce it more toughly, we would have to accept that would lead to more type 2 mistakes, which actually I hear more and more in the debate, is that the Commission should accept more type 2 mistakes because that's the price to pay. I don't believe so. I think that our duty is on balance to implement fairly whatever is the review standard that we do have. So that's the first issue. The second issue, of course, should we change the assessment standard? And I understand that Massimo believes yes. I personally not sure. First of all, I'm not sure it is a digital-only issue. So what about pharmaceuticals? What about credit rating agencies? Well, you may know that in credit rating agencies, the reason why you have only 3 big guys is that each time a small specialized credit rating agencies goes or threatens to go up the glass ceiling, it is immediately bought back by one of the big CRAs. And of course, none of these transactions is ever notifiable because the turnover of these companies is very low, and it's very low compared to the markets that they move with their recommendations. So I think if you enter into the area of having a specific standard for sectoral mergers, you put your finger onto something that I'm not sure I would go along with, and I don't think this is a movement we should take lightly. And then the third question is, okay, should we capture transactions that we do not capture today? And that's the issue you raised with Article 22. What I think is that really, first of all, it's not about killer acquisition or reverse killer acquisition. I mean, as you know, at least in digital, a lot of these acquisitions of nascent companies are not killer acquisitions. But this is because this is the business model in this market. You basically develop, if you develop a successful innovation, you will make your money by being bought back by one of the tech giants rather than by developing your own business. So some of these nascent activity acquisitions have even zero turnover. So there is no turnover threshold that can possibly capture them. And if you think about it, any threshold type system would lead the authorities to review a huge number of cases that have no interest from the point of view of competition, to only capture the very few cases in which you really would like to intervene. So that's the reason why we thought that reversing the recommendation we had taken in 2016 to the member states to refrain from referring cases where they did not have jurisdiction by virtue of the national law was the right way to do it. We will see relatively soon, because the General Court has granted the expedited procedure, what the judges think about that. Personally, I'm quite confident because the Commission has always said consistently that member states can refer mergers below the national competence threshold. We have simply recommended them not to do it, and we have changed that recommendation. So I think that would basically, in a nutshell, sum up what I think. And you're an economist, Cristina, so you know I believe very strongly in the law of Robert Mundell, that with one instrument it's better to try to deal with one issue and not try to solve multiple issues with one and the same instrument, because you risk failing on all your objectives.
could integrate quite effectively, but there's a lot there to discuss. Indeed, I think the type 2 error versus type 1 is a big part of the debate, and certainly the question of killer versus reverse killer acquisition, the buy versus build, is also a big central part in this discussion. But I don't want to monopolize that particular topic. I want to move on to the other speakers, and we can return to this at the end. I want to go now straight to the DMA. Of course, there's been any number of panels around it. No need for introducing it. But Philip, let's go straight to you. So we have these 18 rules, Article 5, Article 6, some are black, some are gray. So are we happy with the current design? The gatekeeper designation, this list of obligations, can it form a basis that is sufficiently prescriptive and importantly self-executing? Is it sufficiently bespoke? There is a big discussion going out there. Andreas Mond keeps talking about the problems with a one-size-fits-all approach and keeps talking about the need to make things more bespoke, a position that I agree with. So how do we see this evolving through the final approval? What would you like to see? What are your views?
Cristina, thank you so much. I mean, to answer your question, let's start by just saying, isn't digital amazing? We can celebrate European Competition Day together, despite travel restraints, with perhaps a global audience, but despite all this great remote connectivity, I'd rather be in Lisboa, sipping a coffee, a duplo, nibbling on some pastéis de nata, exchanging experiences with Margarita and Margareta and Isabel, who's going to bring home the DMA during the next presidency. Hi, Isabel. Exchanging experiences, real connections, real debates, and Cascais just around the corner. So digital is amazing, yeah, but there can be some drawbacks. You miss some things sometimes, right? And so, if you recall when, we wrote our Furman report in the UK, we spent a lot of time talking about the amazing benefits of digital and some drawbacks and some harms. And even if you admit that there are probably greater benefits than harms, regulatory humility and regulatory responsibility means that we have to address these harms. So what are the harms? Well, I always kind of laugh when people say, oh, the DMA, if you look at the various lists of practices, these are just ways of shortcutting cases that have taken too many years, and we're just going to just go through and not have to litigate all these cases in that way and just speed up. But that's not what we were talking about in Furman. That's not the approach of the DMA. In Furman, we were talking about the problems of this new digital economy are primarily structural. Okay, they are features of the market. Network effects, economies of scale and scope, barriers to entry, in particular switching frictions and switching costs, gatekeepers, consumer inertia, tipping markets, all right? And we added onto those structural features some small behavioral aspects, which would normally perhaps be considered under Article 102, abusive dominance and competition. So let's say DMA is just trying to short circuit and get to these bigger. So I heard all this litigation short circuited way bigger than that. It's about pro-competitive intervention. We suggested it in Furman and have been echoed by the CMA authorities to address the structural features. So it's actually a regulatory re-landscaping through those. And if you're going to control features and do a regulatory re-landscaping, it makes sense to tackle the biggest structural features and thus the largest gatekeepers. So in terms of designation, that flows from it. And I agree with Andreas Schwab and some of his suggestions that clearly those kind of designations have to be focused on a small handful of very large gatekeepers. So of course I support suggestions to increase some of the quantitative criteria. But about the features, we're removing switching costs. We're trying to remove frictions. We're trying to make sure that there is not a lack of competition so that we improve choice. and that, I'm not going to stay on the rhetorical level all day, but how do we do this? The pro-competitive intervention that's the most important one is related to interoperability, with core platform services and between core platform services. So that's how we unlock digital competition. So I just want to say that this approach about what's most important in terms of the DMA provisions, or these provisions are coding, I hope, for success. They're coding for compliance. They're coding for making sure that we address the biggest features. We focus, therefore, only on a few gatekeepers. We make sure that there's an active consultation process I can talk about later, about how we ensure that those obligations in the list are tailored to those gatekeepers. Most importantly, we internalize compliance. Hashtag internalize compliance. That means the DMA gatekeepers have to have compliance code officers. They guide every gatekeeper who attest, and the CEO signs off on it to the commission, that we are in compliance with the DMA. And we have to make sure that, therefore, the commission has a compliance unit that is not assessing business launches. It's not. It's assessing compliance. And so I think that we have to rethink some of the institutional aspects, and I look forward to debating that with all of you today.
Thank you, Philip. Let me move on to Agustín, and then I'll get back to you with a follow-up. Agustín, of course, in your role, you have thought a lot about whether these rules are ultimately sufficiently consumer-facing. There's a lot in the DMA which is very B2B, and there is a sense that the role of the consumer, the protection of the consumer. I take Olivier's position that data protection and privacy is a different instrument, but this also matters for market power and the exercise of market power. So tell us a bit about how you, from your perspective, think that consumers' position is being furthered and supported in the DMA, and what else should or could happen.
Excellent. Thank you, Cristina. Great to see you all, at least virtually. And I can only echo what Phil said. Yeah, I'm really desperate to travel next time and meet you all there around a nice coffee. So the DMA, indeed, Cristina, we look it from the consumer perspective as consumer advocates, bear in mind, of course, that all the services that we are regulating are essentially consumer-facing services. So whatever intervention, we need to ensure that this will lead to improving consumer conditions in all these markets or core platform services, as I'm describing the DMA. The DMA, it was a long-awaited proposal. I must say that it provides for a good basis. We don't need to enter into the whole discussion about the interplay with competition law. We see it as a regulation, complementary regulation that targets very specific issues and characteristics raised by gatekeeper platforms, regardless of whether they are dominant in the competition law sense or whether the agreements are capable or not to be captured under 101. Really, we're talking about basically preempting legislation. Very concretely, we think that it's great that this is a regulation, rather than a directive with swift entry into application, contains as much as possible, should contain as much as possible self-executing obligations and prohibitions, and as well to be enforced at EU level. But we consider, at least from a consumer perspective, that it should be improved both at the level of substance and procedure. On the substance, I'm looking specifically at Article 5 and 6. We think that some of the obligations could be further improved. For example, we think that it's really good that the DMA targets data combination, but it falls short, for example, in providing effective mechanisms to prevent gatekeepers from pushing consumers through the SAN interface to accept such data combination. In addition, for example, it's not clear what the choice should be for the consumer is between a personalized and a not personalized core platform service on the basis of data combination. Can the gatekeeper offer a service of substandard quality, making the consumers always to go for a personalized data combined service? So we think that the intentions are actually good. We know that data combination have raised many concerns, but we need to make sure that the tool for intervention is effective enough. Another area that can be further improved, and Philip already mentioned this, relates to interoperability, horizontal interoperability, so between core platforms. There are a lot of discussion about this. For us, from a consumer perspective, it's quite simple. We know there is a market failure caused by lack of interoperability, at least in two well-identifiable services, so communication services and social media. And by forcing only the gatekeepers to operate, we are not putting a burden on SMEs or passing costs on to consumers, because it targets only the gatekeepers who have the scope and the scale to implement interoperability. So this is, for us, a very meaningful and important intervention that could be foreseen in the DMA as such. And related to this, we think that it's very important to have stricter rules to prohibit the gatekeepers from circumventing their obligations or prohibitions through the use of what we call the dark patterns, so behavioral techniques and design interface, to influence, at the end of the day, consumer choices. But then on procedure, and for us it's extremely important not only to ensure that the obligations and the prohibitions are appropriate, but also that the procedure and enforcement is tight enough to avoid that the concerned gatekeepers might gain in the system. So this starts not only at looking at the different provisions, but also ensuring that the Commission, for example, fully resourced to carry its enforcement functions under the DMA, as regard both the number of staff and the type of expertise required in order to enforce the DMA. From a consumer perspective, we think that it should be also important that consumer organizations have the right, and other parties, of course, have the right to submit formal complaints about the gatekeepers violating the DMA obligations, as well as the right to be heard in decision-making processes and market investigations under the DMA. It also implies that the DMA should be enforceable before the courts, including through representative actions by consumer organizations. And finally, and this is an extremely important point, which is kind of the talk of the town right now, is that no efficiency defense should be allowed in the compliance process by the gatekeepers. I would like to briefly refer to this last point. As we know, under competition law, a company can justify its anti-competitive conduct on the basis of efficiencies without weighing anti-competitive harm. The DMA takes a completely different stance. Here we're not discussing whether the conduct could potentially be beneficial or not. Here we're discussing whether certain practices by gatekeepers should be preemptively forbidden in digital markets on the basis of a decision taken following a democratic process. And we can think this as speed rules. In most countries, the law makes speeding illegal. It might not be always harmful, but on balance, society has decided it is best to ban speeding, even though there could be an efficiency justification under some circumstances. And this is a perfectly legitimate choice. And you could imagine the backlog in the court if every driver would argue that their case, in the case of speeding, was justified. And the same arguments would apply to the DMA. And both at EU level and the national level, we have been actually, the legislator has been restricting business practices for decades in order to attain different objectives: market legalization, consumer protection, workers' protection, and the DMA seeks to increase contestability and fairness in these markets, and these are very legitimate objectives which can be attained by prohibiting practices or obligations, even if that would imply sacrificing some, and I say this, efficiencies in favor of those broader goals without having to get the companies to justify themselves. Thank you, Cristina.
Thank you, Agustín. A great run through with a lot of important themes, from interoperability and the debate about how do you avoid that locking in forever the standards of the dominant companies, and the discussion about efficiency defenses, which I think is important because we know efficiency defenses play a minor role in competition, and I think that they should be also kept in that sort of role in any forward-looking regulation. Going back to Philip for a second before we move on. Philip, you talked about coding for compliance, and I want to go back to compliance later, but on substance, what is your view about the current landscape of these rules? They appear to be, of course, and people say they're sufficiently specific, they are kind of close enough to what we need to do. Others feel that these are synopses of competition cases, but there isn't enough specificities in them. As I said, Andreas Mohn keeps saying, in the end, we're going to have to be specific about in each particular case, so we can't generalize in this one slice. You have views on this before we move on?
Yeah, I mean, I think there definitely needs to be some tweaks, and they will happen through the DMA process, I hope. I mean, I have been focusing primarily in my research on institutional developments, but of course, obviously, with respect to the rules, I mean, these rules, I don't believe, are yet self-executing in a way that is tailored enough to address the problems of some of these gatekeepers and also to be future-proof. So I think there does need to be a process, and I think it's an institutional process, where you have some regulatory dialogue with the gatekeepers and you say, look, we're consulting on whether or not you're a gatekeeper. You probably are, so let's begin the process. Here are the obligations from the list, and there may be others, that we think will adhere to you and your business model, looking a bit more like the way the CMA is looking at business models. And we want to have this discussion with you and third parties as to how those adhere to you. And so I do think that kind of process will probably come about, I think ideally, through institutional dialogue with the gatekeepers, rather than perhaps trying to perfect the adjectives at the parliamentary level about what is unfair self-preferencing and what is not. But that's just my thinking, that it would be better to have that open process with gatekeepers and third parties to be able to discuss that, and then you could get to a more tailored list of a code for each one of the gatekeepers, and then you're coding for compliance. You're coding for success. You're not coding to start off with the DMA finding 1 million infringements immediately, or messing up business models and then leading to endless litigation. You don't want litigation to be a feature of this. You know, if anything, you want litigation to be a bug that we try to make sure is only used when we're fighting genuine battles of substance or due process. So that's my answer. I think there does need to be more tailoring. I perceive a better way of going about it would be through institutional engagement, dialogue with the gatekeepers and third parties. Different obligations will adhere to different gatekeepers, and then we move on. But I think we need to code for success from the beginning, rather than have a list of things that are not very clear and that might not necessarily be self-executing.
Thank you for that. That's very much my view too. I'm leery of participative antitrust or anything that looks like let's sit down and then kind of slip into regulatory capture. But I think that clarity and engagement are important, because otherwise what you're going to see is that people are going to say, I'm compliant, and then play dead. Nothing will happen. So let's move on, though. I want to go back to Olivier in the first place. I said at the beginning that although this is an important pivot, an important turning on the road, we certainly aren't giving up on 102, and we shouldn't. What work ultimately will and should 102 do under this regime, post-DMA? And it is particularly important in the light of the plethora of new cases that we see being opened in the last few months and weeks. There is a succession of cases, DG Comp, but not only, Germany, France, and so on. Please give us your vision for how you think this interaction will work.
Okay, well, but first of all, I mean, the idea that I hear sometimes that the DMA is the end of 102 enforcement in the area of platforms, frankly, I think it's nonsensical. There's some different ways to answer your question. The first is to revert to history. I mean, it's not the first time that we decide to operationalize competition principle into an ex-ante regulatory framework. We did it, for example, in 2003 with the telecom framework. And certainly 102 enforcement didn't cease in telecom after that. Here it's a bit different. Of course, because here what we're talking about is kind of a fair trade competition enforcement inspired regulation that tries to provide a self-executable list. And by the way, I'm not sure I agree with what Philip just said, and you seem to agree to, Cristina. Actually, if you look at the list, it is tailored already, because you see immediately, depending on the platform, some of the obligations will not apply to some platform, and others will more specifically apply to some business models and not others. And by the way, there is, as you know, in the DMA proposal, the possibility to enter into a dialogue in order to tailor for individual platforms a number of obligations as well. But I think it's important that it remains self-executable, not least for reasons of legal certainty for firms. And the more self-executable it is, of course, the more precise it has to be. And the more precise it is, the more easy it is to circumvent the obligation by implementing a different practice that is not in the list, or not even less in a tailored list after a discussion, but is actually reaching the same type of effect. So for this, we have two tools. We have an anti-circumvention tool in the DMA, but for most we have 102. So 102 will remain very relevant in that respect. It will also be relevant because some of the practices we see today, we couldn't have imagined 5 years ago. And the reason for this is that technology evolved, services evolved, business models evolved. So I see a bright future for 102, both as complementing and as fitting in into further iteration of the lists of obligation under the DMA. And that, of course, will call for a very close cooperation with member states, not only because some of them have specific laws, you referred to the German law, for example, but mainly because they are in charge alongside with us of the implementation of 102, and we will need to coordinate if we want to have a global enforcement system that makes sense for large platform. We will have to decide which tool we use when, either alternatively or sequentially or together. And these are decisions we will have to take, I suppose, within the ECN.
Take it away. You want to give us your views? If you can hear me.
We can hear you. Did you talk to me?
Yes. Massimo. We can't hear you. No, we can't.
You're muted, Massimo, I think.
No, unfortunately.
As Philip was saying, there are drawbacks to technology.
No, it's a pity.
And Olivier, if I may, I'll just jump in quickly. You're absolutely right. Some aspects of the DMA obligations are tailored a little bit, but just like you're wearing an excellent tie, I'm not wearing an excellent tie, but I'm wearing a bespoke suit, and I think it's worth making things a little bit more bespoke. Not so precise that they get evaded, but having a little bit more clarity as to the obligations and how they adhere to the various business models. Sorry, Cristina, go on.
We wait for Massimo. Perhaps we can move on, come in. But again, I'm on the same page. I don't think I agree, Olivier, that there is, the list is good. One needs to, however, make sure that the targets of the obligations are very, very clear as to what applies to them. Because as I keep saying, this is not telco. The business models are very different, and I, from direct experience, know that some staring at this list to say, I don't know, this isn't for me. This isn't me. I don't do that. It seems to be made that you are actually subject to this and this and this and this and this specific to you. So let me ask if Massimo is possibly back, or we move on to the next topic. Possibly not. Oh, that's too bad. Massimo, we'll pick up with you again if we can in the rest of the panel. Well, in part, we touched upon this. The next issue is really something that, again, Philip touched upon. And so, timing, who does what under the DMA. So one of the key reasons for pivoting towards regulation is this anxiety over the length of the antitrust processes. We know why that happens, but it is a fact that things take quite a long time. This contributes to the sense that ultimately antitrust is not quite as effective as we'd like it to be, because the big transatlantic takes a long time to shift and to move the dial. So how will a regulatory approach like the DMA somehow, in terms of outcomes, improve on this? Will we not be mired in litigation in Luxembourg from the word go? Isn't there going to be significant delay there? And also separately, from the perspective of institutions that Philip talks about, who does what? This isn't entirely clear. There's a major issue of competences between the EC implementing the DMA and the member state. That interplay is clearly much at the forefront of people's mind. Let me start with Philip, and then we'll move on to Olivier.
Thank you, Cristina. Well, if we're talking time and space, I should probably leave the space part, the competences of the Commission and the member states to Olivier to opine on, and certainly get some reporting, I bet, of what he says. But all I would say, obviously, is that there are many very sophisticated agencies at the national level with experts and experience, and stepping stones have already been made, especially in Germany and France. So I'm sure that it makes sense to involve these national experts and institutions, and I look forward to hearing what's planned. I'll focus on time, okay? Time rather than space. The point of ex-ante regulation is to get ahead of the problems. This is not a catching up world. And the point of asymmetric regulation, which is what we're talking about, is to restore balance where there's an imbalance, okay? So we do this, when we have a problem with our digital devices, we reset the defaults. Hashtag reset the defaults, okay? And so we return to an internet of openness rather than walled gardens, an internet of diversity rather than monoculture or duopoly culture, an internet of choice rather than of dependence, okay? And an internet where competition is indeed a click away. Hashtag make competition a click away. We want freedom of movement. We want equality of access. We want equality of opportunity, okay? So in enacting a DMA, we don't code for failure. As I say, we don't code for violations and court action right off the bat. We code for success. How? We code for compliance from the start. And how do we do that? Well, we need to code for clarity. Clarity of obligations, especially with respect to the pro-competitive interventions, open APIs, full interoperability with and between core platform services. We don't refight old battles. We don't maximize the opportunity for references to the ECJ. We don't want litigation to be, really a feature of this. It can be supportive, but we don't want it to lead to fragmented, multiple conflicting judgments at the national or even subnational level to delay things, right? So we need to provide clarity, ideally through guidance, I feel, and through this regulatory dialogue process of making sure that the right code obligations adhere to the right business models. But we need to provide regular guidance and fast dispute settlement and flexible remedies. Now, how do we do all that? Well, Margarita mentioned at the very beginning of the day today that we have, certain values. I think they're European values, but also global values. Open, engaged, democratic, connected, fair processes. And I'll focus on institutional processes. We announce a timed consultation on who will be the gatekeepers and what obligations will adhere to them. We consult. We listen to the gatekeepers and third parties and important stakeholders. We have a regulatory dialogue, not a tea party, a regulatory dialogue, participative antitrust, yes, and we create tailored obligations that gatekeepers can comply with right from the start. And we supplement this with guidance on what do we mean. We've got to get away from this enforcement fear of guidance and only issuing guidance every few years. And then the guidance only summarizes case law. The legal service may not like this, but we have to think a little bit out of the box to provide an example to the digital gatekeepers and the complainants about where safe is and where dangerous is. So not years of litigation, not multiple conflicting court judgments, not fragmented markets. This is an internal market instrument, supposedly. So we have to think for that. So hashtag code for compliance, hashtag reset the defaults, hashtag make competition a click away. And remember, as Olivier hinted at, remember mobile roaming rates? We saw, exploitative and discriminatory rates. Did we use abusive dominance and excessive pricing? No, we didn't. We changed the regulatory landscape. We banished the unfairness, and we can do that too with exploitative and discriminatory data choices and abuses. Okay, so let's get started and learn by doing. Pro-competitive interventions, a compliance unit within the gatekeepers and a compliance unit within the commission that is focusing on making sure these obligations are adhered to. And then, as I would suggest, and Rupert Bodson and I have written about this, a platform complaints panel inside the commission with independent decision makers, ideally. I know that's new, but let's go there so that we can have rapid adjudication and interpretation of the obligations and hopefully not get caught up in multiple substantive appeals, but instead have a different level of judicial review. Thank you, Cristina.
Lots of ideas there. You're not going to do the singing and dancing, but lots of hashtags that we should be pursuing. But I think the more seriously, emphasis on speed and what can be and should be done to make the compliance work rather than being caught in an endless loop of litigation and challenge. Olivier, do you want to give us your view on this issue of who does what and timing and compliance, how we code for compliance, as Philip says?
Well, it will be a lot more boring because I don't code and I don't tweet, so no hashtag here. No, first of all,
can you hear?
Yes, I can. We can now.
Yeah, that's better. So no, we. First of all, what I'd like to say is that antitrust didn't do such a bad job, at least in Europe. And I think it's good that the Commission, for example, rediscovered no interim measures. We saw that it can change a lot of things. We saw how in a year time that allowed us in the Broadcom case to come to a satisfactory solution. And why is it so? It's because it reversed the incentives. There is a reason why these procedures are relatively long and cumbersome, and this reason is called right of defense. So if anybody is suggesting to cut on the rights of defense, I think it's an interesting discussion, but I don't think this is the discussion we should have. So rights of defense are essential, and even big tech have right of defense and should have right of defense. But the problem, though, is that in an antitrust investigation, the incentive of the companies, especially in the digital, is to use this rights of defense to delay as much as possible the investigation, because while the investigation is ongoing, the practice is taking place. And given the speed at which network effects deploy in the digital, of course, the competition is dead by the time you have a decision. The only thing you can do is impose a big fine. That has been the case all the way since the first Microsoft case. So that's one of the reasons why, for the most harmful practices, it's interesting to have an ex-ante prohibition. And that's the raison d'etre of the DMA. But here as well, I mean, one should not underestimate the role that 102 enforcement will continue to play, and that it can be pretty quick as well. Having a review by independent panelists rather than by judges in Luxembourg, I am not thrilled, I have to say. I don't think that private arbitration showed great superiority over jurisdictions, and I even think that it's probably not possible in a legal order, because in the end of the day, if it's a question of community law, it should be for the court to decide. And there as well, they have shown that they can do it pretty fast when time is of the essence. So, and finally, maybe on this point of tailoring the obligations, I wonder whether it's a nice conversation to have on a panel. Is it a real life issue? I mean, do you seriously think that gatekeepers will not come to the Commission and say, well, this is the way we intend to, we believe, first of all, we are subjected to this and that obligation in the list, and this and that are irrelevant for our business model, correct or not? And secondly, this is the way we intend to implement it, because given the sanctions that are at stake, this is what I would expect them to do, and I would expect the Commission, of course, to engage into that dialogue in a way that goes without saying. Should it be specified in the regulation? I'm not sure. You know, I'm a great believer in common sense, and I believe that what you achieve very often by over-specifying in regulations is straitjackets, and that turns out to be more a problem than an asset.
Okay, I think an interesting perspective. I think there is also a danger that people will not necessarily proactively and enthusiastically come over and say, I will do this and I won't do that, but they will just say, I'm compliant, come after me.
Well,
and we'll see
what take the risk, Cristina. Then they will take the risk.
Yes, but this is what I hear. So this is interesting, and I agree with you when you say it isn't true that antitrust is failed, antitrust hasn't done a bad job. I think that no one is questioning the effort and the motives and the quality of the work that was done. The problem is really in terms of outcome after all these years. Inherently, antitrust can only do so much, because while you're spending years doing the shopping, then things are moving on in Android, which you sort of start looking a little late, and then you start looking at that, and then things move on to ad tech, and then things move on to car, and then things move on to things. So it's inherently the case that there's a catch-up, which is why...
But you will see, if I may, Cristina, you will see the same with the DMA. Because what we're talking about is a limited number of platforms for a limited number of very identified practices. Otherwise, it's not self-executable. And do you seriously think the problem in the years to come will be simply confined to these platforms and these practices? No, it will not. So future-proof means you will need to have a feedback loop, which partially will be through the DMA itself, and partially will be through antitrust enforcement, in order to adapt. But this adaptation will never take place in real time, because it's a legislation.
Oh, I agree that there is no sense in which the DMA is a complete solution to this. These problems are inherent. But I'm not the speaker. I'm going to go back to the speakers. And particularly, I hope we got Massimo able to speak now. Are you audible now?
I don't know.
Yes, you are.
Yes.
Can you hear me now?
Yes, you are. Super. So, Massimo, I want you to run two things together in some sense, because I want to give you the opportunity to talk about both the point that we were traversing with Olivier early about, okay, the complementarity with 102, how does 102 play into this mix? I know you have views on this, but also I want you to move on to the other topic I had in mind for you, which is linked to the discussion we're having now about the efficacy of antitrust and whether to some extent the DMA can help us do better in some dimension. And the issue there is remedies. We know that remedies, unfortunately, are a weak spot, because in a cease and desist situation, you tell the dominant company, go and design a remedy, then they come back and it doesn't quite work. We know that kind of saga. And the question is, will we see a difference in the way things are done. The DMA is pretty weak tea when it comes to remedies. Behavioral, nothing structural. And Andrea Schwab has actually been quite vocal that something more robust needs to happen there. Over to you.
Well, first of all, sorry again. I do not know what happened after more than 15 months doing this sort of meetings online. I thought that I had seen everything. Not quite. So I'm sorry I couldn't follow exactly all the conversations, but let me pick on some of the things that you, Cristina, have just pointed out. So on the complementarities, well, I agree with Olivier. I think that of course, that there will be a lot of scope and a lot of room for 102. It will and should have an important role. Clearly, this is for different reasons, part of which have already been said by Olivier. So first of all, it's the DMA just about the gatekeepers, but not necessarily all the possible practices that the gatekeepers are going to resort to. So even when it comes to, say, time and self-preferencing, the impression is that I have while reading the DMA is that, and especially Article 5 and Article 6, is that what happens is that it's going to capture only a narrow subset of the possible time and self-preferencing conduct of those firms. So this means that there is space for the 102 from that point of view. And then there will be new practices that those platforms are going to come up with. And we know that it can be pretty creative. Plus, of course, what happens is that these are all businesses in rapid evolution. So new types of conduct which might be worth looking at will arise. And then, of course, there will be some products and services which are not covered by the gatekeeper. So imagine, for instance, Microsoft for what's going to do in software activities, which are clearly digital and clearly important for digital work, but they will not be covered by the DMA. So overall, I think that the 102 will have a lot of room. I also understand that DMA doesn't have retroactive value, so there will be a lot of cases that will have to be, which have just started or which are already being investigated and which should be finished. And hopefully, what happens is that this might actually change the jurisprudence on 102 or contribute to the jurisprudence of 102. Now, on the issues about what is that antitrust has been able to do in the past or not, and remedies. So first of all, the little I have understood about how the process is working for the remedies is not exactly that the firms are on one side and they just think of their remedies and they come up with a take it or leave it offer to the European Commission or whatever antitrust authority is there. So in general, there is clearly some discussion and some negotiation behind the scenes, although this is not what formally one is perhaps supposed to say. But the problem is that in the past, in my view, and you mentioned at some point Google Shopping, the problem is that the things have moved so much that by then it was very difficult to imagine some remedies which would have been restoring a status quo ante that didn't exist anymore. So this is, I think, one of the issues is that behavioral remedies, if they are immediate, then they can actually try to contribute and solve the problem. And if they come 8 or 10 years later, then there is very little you can do with that. But so this is intimately related to the other question, which is the speed of the investigations. I do understand that rights of defense is important, and I would certainly not advocate against them. But I think that perhaps there is a middle ground between the way in which rights of defense are used and abused now, and sometimes you might actually want to less be thorough, perhaps, and less, guarantee a little bit less, but in the name of having quicker decisions. The other thing which might change in the future is the possibility of using interim measures, which didn't exist until a few years ago. So personally, I think that looking forward, when there will be new issues coming up, I think 1 or 2 might be the way forward. Perhaps with a bigger reliance on interim measures, than a system whereby you would have to extend the DMA through a market investigation and then a report, etc. Which means that 3 or 4 years might pass before you can actually arrive at some decision. Thanks.
Thank you, Massimo, and a good run through and overview there. I want to give the floor back to Agustín, who really hasn't yet set out his stall entirely. Agustín, I want you to take us through what you think. You've already talked about the DMA and your views, but ultimately, what's missing? In my view, there's quite a lot missing. My own personal list includes, for reasons that we know, mergers, and includes a more direct interest in consumers and exploitative practices, and indeed the whole data protection integration point, which we'll discuss a bit later. But what is your list and how to possibly, realistically and concretely make progress on it?
Absolutely. Thank you, Cristina. Can you hear me a bit better now? Because before I was a bit robotic. So now it's better. Yes. Okay, excellent. Yes, one of the things that I would like to mention also, which relates to the previous discussion on the regulatory dialogue, that also fits on this point as well. We are all in for clarity, timely enforcement, timely compliance, appropriate intervention. And that's why we think that the obligation should be as self-enforcing as possible. I know that the idea of a regulatory dialogue sounds kind of very inclusive, but I need to side with Olivier on this, because aside the omnipresent risk of capture, I'm also afraid that actually we are diluting the sense of accountability. Working for civil society organizations, consumer organizations that deal very often with enforcement cases across fields, it's extremely important to have a point of reference where you can make both companies accountable via the courts, but also the authorities. And here we wouldn't like to have the DMA diluting that accountability, or in this case of the European Commission, who will be in charge of enforcement. But then, if we look at the DMA is just one part of a bigger jigsaw. It's composed of competition, consumer, data protection law, the Digital Services Act, so on and so forth. And each area of law needs to play its part. And for that, we need to ensure consistent enforcement and more cooperation between the agencies, which is something that is not often discussed at least at EU level. You, Cristina, often say that we need to bring the privacy people to the antitrust table. Of course, I cannot agree more, but for that to happen, we need to have formal channels of cooperation so agencies can discuss issues of common interest within a framework. So I was thinking more of this type of kind of regulatory dialogue, so regulatory dialogue between the competent agencies themselves. There are good examples, especially at national levels. On the UK, recently the CMA and the ICO has teamed up, in France as well. So I think we need much more of this type of dialogue as well, also to allocate who is best placed to intervene in certain market in relation to specific conducts. You mentioned merger control. This is a big area of concern. The DMA, for legal reasons of legal basis, cannot do much here. But the Commission can, for example, when revising their guidance and notices, so as to better consider the reality of digital mergers. It is good that the Commission wants to have a greater overview of what's going on regarding potential mergers, make better use of the system of referrals. But I think that we need to have a more fundamental discussion about how do we treat these mergers. And from our perspective, based on recent experience, we need to stop treating these digital mergers as conglomerate mergers and think there is no problem per se. Most of these mergers are conglomerate, but only on surface, because in reality, most of them are vertical or have a lot of vertical elements. And vertical mergers can, in some circumstances, be as problematic as horizontal mergers. So therefore, I think we need to have a proper discussion about how to approach these mergers. Of course, we have adverse case law before the General Court. Hopefully, the situation will change before the Court of Justice. But still, I think a lot can be done without having necessarily to change the standard itself. And finally, on the issue of data exploitation and data extraction, which is not really addressed in the DMA, but unfortunately, this has become a sort of blind spot because nobody seemed to be ready to tackle this issue for whatever reasons, a matter of competence, threshold for intervention, case law. But in reality, this has become a serious problem in the digital economy. Consumers are constantly being profiled. Consumer agency is being restricted, basically. And this is the premise for a competitive ecosystem in which consumers vote with their feet. So we really need to tackle this issue as a matter of urgency. And a way to do is to try to first bring in the relevant agencies and authorities on the same table and discuss what is the best way to intervene in this regard to protect consumer agency. We have been working at looking at how consumer law, for example, can be adapted to play its role, but certainly competition law can play its part. The DMA can play its part if we look, for example, at the rules around data combination or restrictions to data combination, and really think about how to approach this in more holistic perspective. I know this is a sort of cliche, but in reality, we have practices that can be looked from all these different perspectives. And we need the regulators to come together and talk about these issues in a regulatory framework. Thanks, Cristina.
Thank you, and I'm particularly excited about the last call to arms. I think I agreed with everything you said, but let me just pause for a second. Your remarks and the work that consumer association, civil society, and privacy data protection experts are doing to highlight the problem of data extractivism and the importance of it is super important. It is one that I think is not yet sufficiently given the weight that it deserves in an antitrust discussion. Olivier, you're right. Of course, we have traditionally even looked at data as an asset, data as a dimension of quality, but it is, I think, time to move beyond because we have operated as silos as antitrust agencies and data protection operators. The antitrust agencies are tasked to deal with the market power, but then if we don't deal sufficiently with the market power, the data protection people are there fighting the giants with plastic knives because they don't know how to enforce against people much bigger than them. So this is an area where exploitation, extractivism really needs to come, to my mind, more fully into the discussion. But we can probably have a final roundtable of thoughts around this at the very end. I want to introduce the last topic, and then we can take some questions also from the audience. I wanted to remind people that it is possible. There should be a link that you can use to ask questions. I see a couple, and I'll ask them to the speakers. But if you have more, that's good enough. Last topic before the final comments. We want to think a bit about the international scene. Okay, so I certainly have been, over the years, a major supporter of the effort that the Commission has made in enforcement. I ran an event in Washington in 2019. We had people locally weren't too happy with me. The ABA were not happy with me because the event was Europeans leading the way in enforcement globally. And I think that is the case of that. At the same time, we've seen a major catching up in the last year or so, unexpectedly to some extent from the US. We've seen the federal agencies moving on. We've seen the state AG complaints. And I think quite remarkably, in the last week, we have seen this collection of bills. They are draft. They are, of course, proposed by the Democrats, but there is quite significant bipartisan support. And some of them have got some incredible names: the Platform Anti-Monopoly Act, the Platform Competition Opportunity Act, the Ending Platform Monopoly Act. I mean, this is not weak stuff. The provisions in there are also quite ambitious. Okay, mergers, complete reversal of the burden of proof, if not a complete prohibition. There is effectively irreconcilable conflict of interest as between a platform and a business that it runs on the platform. Prohibited, break up. So there's quite a lot there. So I'm interested in, of course, Olivier, you have a lot of discussion with your counterparties and interface a lot with US agencies. How is this dynamic changing? How is the DMA playing into this with this novel sentiment and effort in the US to actually go ahead of the game, it would appear? I know this is approved and there will be years, but I mean, it would appear that they listened and there is a great deal of converging on what needs to be done. First Olivier and then perhaps Philip on this.
Yeah, thanks, Cristina. I think I can be short on this. I mean, first of all, it's very welcomed that we were joined back by the US. In the past, I think what we testified is we have very different culture. They have a tendency, believing more than we do, in the capacities of markets to self-fix the deficiencies associated with market power. And of course, I mean, in the end of the day, probably it self-fixes, but the question is, for how long are you ready to accept a loss of wealth or a capture by the dominant player? And I suppose our time span is shorter than the one of the US, and that's why we tend to be more interventionists. So now it changes, although I have to say it's not all that clear that this is the EU going ahead. And because, for example, if I look at the legal standards, I think in that field, the US have a clear advantage with the infringement of monopolizations, which we do not have in Europe, and that allows them potentially to do a number of things we would have great difficulties to do and bring cases which are really difficult to bring with our own standard of 102. So this being said, indeed, it changes. We see these bills in Congress. We had started with the DMA, so although I agree with you, probably it would have been good to have a kind of a global standard. That's not the way it happened, and in a way, it's not too bad. I think we influence each other, and of course that's not the end of the story. Is it that one way of doing things will prevail? I mean, a bit the GDPR sets the global framework in the end of the day, or not? I don't know. I think it's a bit too early to say. What is likely is that going forward, once we will know what is the US standard, because we pretty well know what we want to do with the DMA. It's a bit more unclear, I have to say, on the other side of the Atlantic. What is clear is that they want to enforce more their current rules, and that they want to go much further potentially to breaking up companies, a power that we have and that we would have also in the DMA, as you probably noticed, but that we have never used so far. And there are a number of reasons for that, and I leave you to guess whether it is so likely that the first time we will do it will be for a non-EU corporate with all the political issue that may create. So, in a nutshell, I think what you see is a great convergence on the objective at the moment. Whether we will converge on the means is still unclear, but we don't think we can wait.
A good line to sort of end that comment on. Philip?
Yeah, two things. First, I can't let go a comment from Olivier. If he was an academic, I would say that when he was repeating a thing I said as if it was that I would replace judges with independent decision makers, I would say, Olivier, you're raising a straw man. But Olivier is not an academic. I have to be much more respectful. And so I have to say I need to clarify better my position. My position is, I think that we need to have some forms of new thinking of institutional structure to be able to introduce more due process, actually, into the assessment of these digital practices. And I think that a platform complaints panel of, I would suggest, independent decision makers, but they could be national experts, whatever, would allow, first of all, not having to wait for the judges. The judges are still there. We're just a complement, a supplement, but you don't want to wait 12 years. Justice delayed is justice denied. But you would actually allow the gatekeepers to be able to have an engagement with the decision makers. And then, of course, there can be a judicial review of that decision. So that's one of the things I wanted to say. But Cristina, sorry for being so impolite. I'll go back to the international question. The U.S., waking up and these other things, it shows that the ex-ante regulatory movement is not some weird Eurovision contest ability and fairness thing. It's about European competition values are actually global competition values. It's not some resurgence of the ordoliberals. The ex-ante movement is a necessary answer to an existing danger, and so, it's just like when people criticize the Australians for their legislation that we've seen recently, and say, oh, that's a sop to Rupert Murdoch. No, it isn't. It's a way of rebalancing power, and so I feel that the ex-ante movement is now clearly global. It's a global vision, but it's based on certain democratic values of empowering consumers, empowering citizens. And I think if we internalize within the gatekeepers some of our values of connection, of choice, of freedom of movement, then we'll see a really nice international result. But we have to do it by learning by doing, not by waiting for multilateral rules.
Thank you. And I like the reference to the notion that trying to export ideas like fairness and contestability, which are fundamentally Europeans in the US, isn't quite the point. The motivation in the US comes from somewhere else, but there is a common objective, which I think is the important driver for what we see. Massimo, do you want to comment on this or anything else that you have heard? There is a question from the audience, which is actually directed to you, and I may go there, but I wanted to give you the opportunity to make a couple of final comments before.
On something which was discussed before, which was related to possible exploitative abuses.
Exactly,
and,
very good.
Which I think it's an interesting topic, and one which perhaps we economists have been too dismissive in the past. So I think there is a very fine line between consumer protection, privacy, and competition. But competition is also involved. So think, for instance, of these situations in which, imagine that there is a merger. This leads to more data extraction and to discrimination of consumers. You can dismiss this as saying, well, this is a problem for consumer protection or for privacy. But, after all, when you are evaluating a merger, you think that, there is a problem with consumer welfare as well. And to the extent that it is going to decrease consumer welfare is something that you want to look at. Or again, imagine, for instance, that there is a platform which is going to distort the choice of the users so as to push them to buy certain products or services which are going to be more expensive for them and more, giving more income to the platform. And I'm not necessarily talking about self-preferencing. So, you can say, well, given that you are not showing the consumers what they might want and you force them somehow to buy certain things, you might consider this is a consumer protection issue. But at the same time, this is going to decrease transparency in the market. People are not able to compare the different offerings properly, and this will have a competition impact. So in other words, there is a lot of interaction between consumer protection, privacy, and competition, which I think we shouldn't dismiss too quickly. And I think that there might be a lot of interesting exploitative abuse cases in the future, which have got a little bit these characteristics of being at the crossroads between these different issues. Thanks, Cristina.
That's great, because it is exactly personally how I feel. I think economists have been perhaps in the past a little dismissive about exploitation. I feel that there is reluctance yet to go there. And it is curious that when you're talking about things like degradation of data protection and privacy, it is not seen as something germane to the economic analysis of a deal because it's about the data protection people over there. But it directly affects consumers, as Massimo just says. So we worry about price effects on consumers. Why not worry about not just quality degradation, but the direct effect of a privacy violation and degradation of data protection? This is something that is capable of being incorporated in analysis and should. Let me, we have only a few minutes left. I will want to remain with you, Massimo, very quickly, if you can provide an answer to a question in the chat, which is directed at you. This is a question about your comments on reversal of the burden of proof in merger control, how to avoid damaging competition in the long run. Will this cause to diminish innovation in markets? And in the same scenario, how will competition authorities establish the limit between generating efficiencies and defending against anti-competitive? In other words, the sort of usual question about what does the reversal of the burden of proof do to innovation incentives and all that. You want to take that up quickly?
Yeah, there is a big discussion about that, and the problem is that it is true that most of these startups now have as exit mode. Exit mode meaning how you develop in the jargon for startups. The main exit mode has become being acquired by a larger firm and not really an IPO as it used to be 15 or 20 years ago. But, I'm not saying that there should be a moratorium against all possible mergers with startups. I'm just saying that, in some situations, there might be some takeovers which are more dangerous than others. So even for some of the famous merger cases that we have seen in the past, say Google Waze, I mean, we saw that not only Google was interested in Waze, but other companies. And so there the issue should be, well, given that Waze had probably a product which was going to be going to basically into the core business of Google, then you shouldn't allow Google to take over Waze, but somebody else might be. So first of all, universal proof doesn't mean that firms should not be able to take over startups at all. And second, you can have different takeovers there, and there is not just necessarily only one which is available. The counterfactual might not be a merger at all. The counterfactual might be a merger with another company than the one for which the startup is a potential competitor.
Wonderful. So we're just over a minute away from the end. So I think I would like to give Olivier the opportunity as our host and of course the most senior person in this panel to just make a final valediction and comment, and then I'll wrap up. Thank you, Olivier.
Well, thank you, Cristina. Well, the host is Margherita here, actually. But now what I'd like to say is, of course, I agree. I mean, it's a continuum, right? Privacy law, consumer law, but at the same time, it's a question of efficiency, a choice of instrument. I mean, you cannot subsume all problems in the world into competition law. It's not effective. It lengthens the investigation, it makes weaker cases. In the end of the day, you have a less effective enforcement. So we had this discussion today as if the DSA did not exist. Well, the DSA actually exists, and there is a specialization between the two instruments. The DMA is about operationalizing 20 years of competition law enforcement and jurisprudence in order to try to prevent ex ante the most harmful conduct in terms of openness of the market, opportunities for challengers to grow and contest the incumbent. And the rest, which is not less important, is being dealt with in the DSA. And as usual, when it comes to enforcement, we will enforce competition law taking into account the regulatory framework, be it in data, be it in consumer protection, etc. And I think this is the way it works. So it's not binary, it's fluid.
Well, and we are just on time, at time, 000. So we got to the end. I want to thank profusely the speakers for making it a lively and interesting discussion. Olivier, Massimo, Philip, Agustín, thank you so much. And the audience, of course, for sticking with us. And have a wonderful rest of the day with the European Competition Day. Thank you very much, everyone.
Thank you, Cristina. Thank you, Margherita.
Bye. Thank you all.